All right, hopefully everyone had a nice lunch. Adam LaHood, who are you here for?
Judge Damian Liao, we're ready to, once we get the paperwork finished on him, we'll be ready to plea. And I'm also here on Clinique Boyd.
All right. And where is Miss Boyd?
She should be on, Judge. I spoke with her and she should be on or logging on here very soon.
All right, thank you. And then the court, once I have your paperwork, we'll take care of that.
Yes, Judge. On Miss Boyd, I think we're at an impasse. I think it's one that we're going to need a trial setting on, Judge.
All right, just one moment. All right, just give us a second. Once she appears, we'll take that up.
Thank you, Your Honor.
You're welcome. All right, Ms. Burgess, can you, Mr. Hilly, are you here?
I'm here and I'm ready to go when you are.
All right, thank you. Who is the attorney on Eblin Acosta?
That's me, Your Honor, Michelle Hayden.
All right. All right, Mr. Hilly, can you show your video, please?
Thank you, Your Honor. Ready to go. And also, I do have a potential witness for bond in the waiting room. I forgot her name.
Turn right onto US 90 West.
All right, the court is calling 2021 CR 11159, State of Texas versus Eblin Acosta. Could I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Thomas Hiller for the defense.
And are you Mr. Acosta?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Acosta, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision or Deferred Adjudication. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Acosta, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Acosta, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with arson of a habitation or place of assembly? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront Any witnesses the state would call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Acosta, has anyone threatened you, coerced you, or placed you in fear to get you to enter into this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be at a cap of 6 silent. There's a $1,500 fine. State remains silent on your application. There's to be TAP evaluation, a MIC evaluation, and no harmful or injurious contact with Tiffany, Tiffany Acosta, or the children you have with Tiffany Acosta. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
Yes, Your Honor.
State is at the plea bargain agreement.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
None, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
State offers State's Exhibit 1 its attachments and evidence.
Any
No
objections?
objections. None.
Mr. Acosta, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand it? And did you electronically sign it in all the
Yes.
appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Ms. Ferguson, could I have a sentencing date in the chat box, please? All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Your sentencing date will be set for May 2nd. Ms. Reyes, I'll need a MIC evaluation and a TAP evaluation. Mr. Acosta, were you using drugs on this day?
Yes, ma'am.
All right, do you have any prior mental health issues?
No, ma'am.
All right, so Ms. Reyes, then the MIC evaluation is probably going to say that any issues that he had were drug induced. So if we can do, just do the MIC evaluation anyway and a TAP evaluation.
Yes, ma'am. A PSI included?
Yes.
Okay, thank you.
Well,
Your Honor,
yes.
if I may, I do
Yes.
have the wife, the victim in this case, Ms. Acosta, on the way in the Zoom waiting room, and she was hoping she can be heard in support of her request for a personal bond, please.
And Judge, the state is not in agreement with a personal bond.
All right,
Oh.
we're at the record. Just one moment. Ms. Acosta is connecting. Just 1 second. I think her audio is connecting, Ms. Hilly. Mr. Hilly, just give me a second. All right, Ms. Acosta, are you there?
Yes, ma'am.
All right. All right, Ms. Acosta, you're
Yes,
not
ma'am.
under oath. We're not on the record. I just have a few questions for you. What
Okay.
are the ages of your children?
I have a 2-year-old, a 4-year-old, and a 7-year-old.
All right, is Child Protective Services involved?
No, ma'am.
All right. I don't know why they're not involved. Are the children living with you?
Yes, ma'am.
Judge, I
All right,
think
so
oh, sorry.
Yes.
Your Honor. We'd requested some CPS records, and I think they were involved if they're not anymore.
all right. So Ms. Acosta, this is something that I want you to understand.
Okay.
And I want you to listen to me very carefully. I understand that the defense attorney is going to be asking me for a PR bond. So your husband, your spouse, your significant other can be released.
Yes,
But
ma'am.
I read the police report and you were involved in the police report. So I know you know what happened. So basically what my understanding from reading the police report and my short conversation with your husband is your husband was on drugs. According to the police report, you told them he had been up for 3 nights straight.
Yes,
And
ma'am.
he set the apartment on fire with you and your 3 children in it. So at some point in our lives, we need to do what is best for our children. Your children, the 3-year-old, who's the youngest, cannot protect themselves from parents who are up 3 days straight using drugs and decide to set an apartment on fire. So we can have the hearing if people want to present evidence, but I'm not inclined to give him a PR bond and allow him out of jail without a bond. And if he were to get a bond, I'm going to order that he have no unsupervised contact with children. And the people who are going to be responsible for supervising him if he has contact with his children cannot be you. And the reason why it cannot be you, because it is, you appear to be more concerned about him than the children. Because again, I have someone who before me, and Mr. Costa, you know this is you. I have someone before me who was up 3 nights straight, either because he's using drugs, which is probably it was meth, and he set the apartment on fire because he started being paranoid from using drugs. So what could have happened in that apartment, what could have happened is you could be dead and your 3 children could be dead because your husband decided to use meth or whatever drugs he's using that is keeping him up 3 nights straight.
Yes, ma'am.
And I don't know who is or who is not looking after these 3 children, but someone has to. So it appears that I've been put in that position to do that. So I'm not granting a PR bond for him. And as a matter of fact, this will be added to his bond conditions if it's not already there. He is not to have unsupervised contact with minors.
Okay.
And there must be adult supervision. And according to my ruling, Tiffany Acosta cannot be the person who's the supervising adult.
Okay.
So that's where we are.
Yes, ma'am.
And so, Ms. Acosta, I know because I've done child protective services cases before, and I'm sure Mr. Hilly knows because I know he's done child protective services cases before. The children are with you, and if CPS is not involved right now, they're not involved because Mr. Costa is in custody.
Okay.
And you have probably promised CPS that Mr. Acosta is not going to be around the children. And so CPS is out of the children's lives. So now we have 3 vulnerable children in your care, and you're trying to get Mr. Acosta out of custody to be with you and the children, when I'm sure CPS said he was not supposed to be around because he hasn't been doing a service plan while he was in jail. Mr. Acosta, have you taken parenting classes at the jail?
Yes, ma'am, I have.
Did you complete it?
No, ma'am, I didn't.
So I know that CPS wouldn't lift plans and say, the children are safe, Mr. Acosta can be around them. I'm sure they're saying the children are safe because Mr. Acosta is in custody. So you, Tiffany Costa, you're in charge of supervising the children.
I just want to say it was an accident, ma'am.
Pardon?
It was an accident.
No, it was not. Let me read you the police report.
Your Honor, me and my 3 kids were asleep at the time.
No, Mr. Acosta, it was not an accident. He set the fire, and in the police report, it says he set the fire. He admits to setting the fire because he thought you and the children were in danger. And the reason why he thought you and the children were in danger is because he hadn't slept for 3 nights because he was up doing drugs. It clearly states that in the police report. I spoke with O1, who stated that S1, which is the suspect, admitted to starting the fire. When asked by O1 why he started the fire, S1 stated that it was for the protection of his family. S1 also admitted to O1 he used the white colored lighter to start the fire, which S1 had in his possession. The white lighter was taken as evidence. And you know who ended up waking up the family? Your next child, not the 3-year-old. The other child said, hey, there's a fire going on here. He woke everyone up. I then interviewed O2. She stated that she and the kids were asleep when the fire started. One of her children was woken up by S1 yelling that there was a fire. The child then woke up O2 and said that S1 was yelling for her. So child wakes you up. O2 stated that S1 had been up for 3 days straight and has been paranoid about people out to get his family. I asked O2 if S1 does drugs. O2 stated that S1 only smoked weeds and has been clean for crystal meth for 3 weeks, but she is not 100% sure he is still using. So the fire was not an accident. He had been up 3 days from using drugs and he was paranoid.
Your Honor, there was people following me from my apartment to my work.
Okay, Ms. Acosta, let me ask you this. How is setting the apartment on fire with you and the children in it protecting you from people who are following you?
Your Honor, I did not know how the fire started because like I stated in the statement, me and my 3 kids were asleep in the back room.
All right, so anyway, I don't know why Child Protective Services closed this case. It appears that it really should be open, but I can only deal what I can deal with before me. And the way I'm going to handle that is this. Mr. Acosta, and
Yes,
could I
ma'am.
have the clerks bring me a B page? Mr. Acosta, if you are released from custody,
Yes, ma'am.
you are not allowed to have unsupervised contact with any minors.
Yes,
And
ma'am.
Miss Tiffany Acosta is not allowed to be the adult who's supervising things. Do you understand?
Yes, ma'am, I do.
All right, I'm going to send you to breakout room number 1. Probation is going to go over what is expected of you. And Mr. Acosta, you need to start accepting responsibilities for your
Yes, ma'am.
action. And you're going to have to stop using drugs. The
Yes,
question
ma'am,
is
I
going to
am.
be, what's more important, drugs or your children? You
My
understand?
children. Yes, ma'am.
All right, I'm sending you to breakout room number 1. Mr. Hilly, you can go to number 1.
Thank you, Your Honor.
Oh, and after that, can I be excused, Your Honor?
Yes.
Thank you.
And Miss Acosta, you can visit your husband at the jail. I think they do that through Zoom.
Okay, can you send me the address or can Mr. Hilly send me the address?
I believe it's still 300 North Kamal.
Okay, I can go visit him.
Yes, but do me a favor, and this is just one of my side things. Don't take your children to visit him or visit anyone at the jail. Of course, if you want to do that, you can, but the jail is a very germy place, and young children whose immune system is not built up should not really be at the Bexar County Jail, but they're not my children, so you can do as you choose.
Yes, ma'am. And how long does he have to?
Everyone, just give me a moment, please. All right, anyone else ready?
Judge, I just need Mr. Acosta to go into that breakout room, please.
All right, Mr. Acosta, you're needed in breakout room number 1, please.
Yes, ma'am.
Thank you.
Judge,
Mark McKay?
yes, Judge. Brian Cruz, he was scheduled today. I've left messages. I've spoken to his wife. Supposedly he's sick. He didn't make an appointment with me last week to prepare for trial because he was sick. I don't know what to do.
All right, well, the court needs some documentation that he is sick. To the clerks, could I have the file on Brian Cruz, please?
And Lorraine is also here. She's on one of his 3 cases.
All right. All right, is there a prosecutor available?
There's some documents to what?
Ms. Fergus, can you see if Mr. Acosta can go to breakout room number 1? And is there a prosecutor available for Brian Cruz, please?
Yes, Judge, this is Brittany. My camera is not working on my computer, though.
Is
All right, thank you.
in person or through Zoom?
All right, we're going to go on the record. Court is calling 2021 CR 8689, 2021 CR 8690, and 2021 CR 9980, State of Texas versus Brian Cruz. Can I have parties announced for the record for the state?
Brittany Sparks for the state.
For the defense?
Mark McKay for Brian Cruz, and I represent him on 2021 CR 8689 and 2021 8690.
And Lorraine Ephron here for Brian Cruz. I represent him on the other case.
And just for the record, Judge, it's my understanding that he did show up online this morning. I don't know what happened. I was in announcing on 3 other capitals, so I didn't make it at the time. But I think Lorraine indicated to me, and she would know, that he was on at one point this morning.
I did see him on here this morning. I didn't have a chance to talk to him because I was also, going around quite a bit.
All right. Well, the court did not, I trust that you say you saw him, but the court did not see him on, but he needs to be here and no announcement was made. So have either of you been able to had contact with Mr. Cruz, Mr. McKay or Ms. Ephron?
I have just been emailing his wife. I don't know that she can talk right now, so I'm just emailing her because I think she's at work. But like I said, he wasn't able to make an appointment with me last Thursday because he was sick at that time. And I don't particularly care to show up for trial tomorrow and have somebody sick.
Okay.
If the court would consider one reset on this, even if it's a short time, just so I can maybe get him in, that's the only thing that I can do, judges.
All right, state.
Yes, Judge, are you asking in regards to him not showing up today?
Yes.
Okay, yes, Judge, the state would ask that you forfeit his bond and issue a warrant.
All right, Deputy Laura, has Brian Cruz been in the courtroom at all today?
No, Your Honor, he has not.
All right, and then as the court stated, Brian Cruz is not on the Zoom screen. This hearing was set at 9 a.m. It is now 2:26 p.m. The court will grant the state's motion. Mr. McKay, Ms. Efron, if you're able to provide the court with documentation that your client is suffering from some illness, then of course the court will reconsider. And if your client appears in court tomorrow, the court will reconsider.
Okay.
All right, thank you.
Thank you, Judge.
Thank
You're
you,
welcome.
Judge.
You're welcome. All right, Richard Langlois.
I'm here, Your Honor.
Yes, who are you here for?
I'm here for Ronnie V. Lopez, as directed by the court.
All right, what is happening with this case?
Well, I don't know what's going to happen. He's set for a sentencing, I believe,
All right, just one
or
moment.
PSI, whatever.
Just 1 second, Mr. Langlois. All right, is Mr. Lopez in the courtroom?
Yes, Your Honor.
You're at the jail. Okay. Who is the prosecutor on Lopez?
I am, Your Honor. Michelle Hayden.
Okay, just 1 second. All right, the court is calling 2020 CR 5979, State of Texas versus Ronnie Lee Lopez. Could I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Richard Langworth for Mr. Lopez, Your Honor.
And are you Ronnie Lee Lopez?
Yes, Your Honor.
All right, we were set for sentencing on October 28th, but the defendant was a no-show. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
I have, Your Honor.
Any objections to the PSI report?
None,
None
Your
from the
Honor.
state.
All right, Ms. Hayden, any objections with us proceeding by video?
No, Your Honor.
Mr. Langlois, any objections with us proceeding by video?
No, Your Honor.
Mr. Lopez, any objections with us proceeding by video?
No, Your Honor.
All right, as previously stated, this is the State of Texas versus Ronnie Lee Lopez in cause number 2020 CR 5979. According to the plea bargain agreement, punishment was to be assessed at 4 years in the prison, and the state is opposing your application. Mr. Langlois, is there anything you wish to say on behalf of your client?
Judge, there is a PSI that was prepared. not sure if the court's had a chance to look at it.
Yes, I reviewed it.
Mr. Lopez has some redeeming values. He can work, he can support himself, and he's been basically staying out of trouble. So this court has a couple of considerations. They can impose a sentence of confinement, or the court can put him on some type of treatment, substance abuse track and cognitive behavior track that he could use that to help him out, get back on his feet. It's up to the court whether you want to incarcerate him or give him the opportunity to for treatment recommendations, such as substance abuse and things like that.
All right, state.
Judge, the state is opposed to his application for probation. As the court is aware through his PSI, he's had multiple chances on probation before, each time getting revoked. He was recently on felony probation in Karnes County, and he was granted 4 years probation, which was subsequently revoked, and he was sentenced to 2 years on that. And then in 2016, he was sentenced to 2 years in prison for the same offense in Bexar County. The facts in this case, he slapped, pushed, and grabbed the victim. He choked her not just once, but twice. And he also threatened her with a knife. And also he no-showed for his previous sentencing. So for all those reasons, we don't believe he's a good candidate for probation.
All right. Mr. Langlois, why wasn't your client present
Let me
for his
have him.
sentencing?
Yeah. Mr. Lopez, would you
All
like?
right, if you
Yes.
could raise your hand, Mr. Lopez. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record, please.
Ronnie Lee Lopez.
Mr.
right.
Lopez, can you explain to the court why you were not here?
Yes, Ms. Judge Boyd, I'm not here to, to make this even more difficult than it is. I went to court. I was in the courtroom waiting. I'm not putting it on my lawyer or anything, but I just got freaked out because he wasn't there yet. He was on other cases, and I understand that. My wife is, she's having seizures. She's going through mental health illness, and I just didn't want, and nobody wants to be locked up in jail, and I would really appreciate it if you can consider me on probation. I will do it. I will do what needs to be done. I just freaked out and I just left because my lawyer wasn't there, but I'm really not a bad person, Miss Boyd, Miss Judge Boyd. I mean, I would love the opportunity to show y'all on this probation if y'all would give it to me, please, and consider it, please. I mean, I'm a good, hardworking guy. I work on sheet metal roofing.
The wife, let me ask you, the wife who has the seizures, is that the complainant in this case?
Yeah, yes, Your Honor.
Okay. All right. Anything else, Mr. Langlois?
No, Your Honor. Obviously, we're asking you to give the possibility of putting him on probation.
All right. And Mr. Lopez, I always read the PSI report. You've been here before for assault family second. Was that the same complainant?
Yes, Your Honor. Yes.
All right. Okay. Thank you, Mr. Lopez. All right. The court is denying your application. The court will find you guilty, sentence you to 4 years in prison. There's a $1,500 fine, time and money to rank and current. There's an affirmative finding of family violence. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over the definition of weapon or ammunition, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Lopez. We can go off the record. Mr. Lopez, if you love somebody, you don't put your hands on them in anger. Do you understand?
So can I ask what's happening?
You're going to prison. Ms. Ferguson, 17B can go back. Thank you, Mr. Langlois.
Judge.
All right. Hector Garza?
Your Honor, how are you?
Yes. I'm doing great.
My apologies. I'm sorry?
Who do you have?
I have Saul Martinez. I'm sorry for running late. We got notice of this setting on Saturday and saw the email this morning.
All right. So is your client still requesting a jury trial?
Yes, ma'am.
All right. We will see you all. Let me check.
If I'm not mistaken, I think he's still incarcerated
Okay. Just one
or
moment.
in custody. Excuse me.
All right, Mr. Martinez. Saul Martinez. Ms. Ferguson, can you check to see if Saul Martinez is in custody?
Yes, ma'am.
No, your client is on bond. It shows him as being on bond.
There you go.
So, your client is not here and he hasn't appeared on Zoom all day.
All right.
All right, is there a prosecutor available?
I'm here, Your Honor.
All right, the court is calling 2021 CR 7015, State of Texas versus Saul Martinez. Can I have the parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Hector R. Garza Jr., Your Honor.
All right, this was scheduled at 9 a.m. It is now 2:38 p.m. Defense, have you had any contact with Mr. Saul Martinez?
We have not had contact with him today, but once again, Judge, I will remind the court that we were given notice of this setting on Saturday. So we have been trying to get a hold of our client today, but we have been unable to get a hold of him. I can only presume that he's at work. So I just want to make certain that the court is aware that we were notified over the weekend to appear today.
All right. And so what I can tell everyone is that before the court would give everyone the Zoom link, and we would give everyone the Zoom link a month in advance, but attorneys would lose the Zoom link in their email or say they didn't have it. And therefore, to help everybody out, we would do the Zoom link the next day. But this is set for today. So, state?
We ask that you forfeit his bond and issue a warrant.
All right. And the defendant,
And Your Honor, we're going
Deputy
to
Laura.
oppose that the bond be revoked, Judge. Again, we are set for trial tomorrow unless I'm mistaken. So my client knows to appear tomorrow. Neither he nor I had notice to appear today.
All
So
right,
to issue
I
a
think
bond,
you should then call him and tell him he needs to appear on this Zoom today. We're here till 5 p.m.
I will do my best, Judge, but again, we will stand opposed to any type of revocation of his bond to be issued. If
All right, and that'll be noted.
Then
But
we
he
will
needs to be
address
here
the
by
issue.
5.
Yes, ma'am.
All right, Clinique Boyd, Adam LaHood.
Yes, Your Honor, we're here, Judge.
Yes.
So we've conferred the state judge. I think we are at an impasse in terms of resolving this. We're going to probably need to go for a trial setting at this point, Judge, or a trial date.
All right, Ms. Ferguson, can I have a trial date for Clinique Boyd, please? All right, April 26th.
April 26th. Clint, did you hear that?
She's on.
I did, Mr. LaHood. I did. And Mr. LaHood, can you hear me as well?
Yes, ma'am. Clinique, I'm going to give you a call here in just a little bit once we're off docket, and we can chat, okay?
Thank you, sir. That's exactly what I was going to ask you. So just to clarify, the trial date for April 5th, which is tomorrow, is no longer a thing.
Now,
Yes, ma'am. Oh, I'm sorry.
Yes.
I'm sorry,
Ms.
Judge.
Just 1 second. Ms. Ferguson, the April 26th date is the date you put in the chat box for Ms. Boyd, correct?
Yes, ma'am.
All right.
You
Yes.
can disregard April 5th.
No, it's not April 5th. It's April 26th.
Very good. We'll see you in person that day, Judge.
All right. Thank you.
I think I'll be with you this afternoon.
Thank you, Mr. LaHood.
Thank you, ma'am. Have a good day.
This is some.
Okay. Is there any attorney left on the Zoom screen?
I'm still here, Judge. We're just trying to get the paperwork worked out on Leal, my other client, but I anticipate we could have this one knocked out today.
All right. Thank you. All right. And Matthew Allen, who are you here for?
Here on Sammy Villa, contested FTR.
All right. And where is Sammy Villa?
He was outside. I think he went to the bathroom.
Yes. All right. Thank you.
Judge, this is Michael Rivera. May I speak?
Yes.
My lawyer just texted me a few minutes ago. He said he's not going to be able to appear. He said he was going to email the court. I don't know if he did. His name
Who's
is
your
Eduardo
attorney?
Eduardo Jimenez.
Yes, the court doesn't have that information from him.
Okay, so I just wait?
Yes.
Okay.
Judge, this is Johnny Clark. May I speak?
Yes.
I didn't understand the last plea that my lawyer brought me. Is there any way I can talk to my lawyer before we
Who's your
confer with you?
attorney?
Mr. Martinez?
Ray Martinez?
No, I forgot. I'm having a brain fart right now.
Yeah, that's very disrespectful. Just say that you don't remember.
I'm sorry about that.
All right. David McLean, who do you have?
Judge, I am here on a status conference for a Article 64 hearing on Jose Cavassos.
Okay, just one moment. And the state is here on that one as well.
I think so.
All right, Hank Wilkins. Hank Wilkins. Yes, we can't hear you.
Judge, is that better?
Yes.
Sorry about that, Judge. Yes, ma'am. So we have an order for funding that has been submitted to the lab, the March 10th order. We reached out last week to the lab, and they have everything they need to start the testing, but we are not sure. We don't really have an estimate for them yet. How long the testing itself is going to take, Judge.
All right, just one moment. Let me get a file because I don't have this file. Just one second. All right, Mr. McLean, Mr. Wilkins, this case is on the docket, but I don't have the file. So I'm waiting for the clerks to get that file for me. So
Good, Judge.
just give me a moment.
Yes,
No
ma'am.
problem.
Do you have an idea how long this will take, Mr. Wilkins or Mr. McLean?
This hearing,
No, I mean the funding. My understanding is that
from my understanding, the funding is there. And that was all that really Bear County Forensic Lab needed, was to just make sure it was going to get paid for somehow. They have several items to test, to go through. And so it's probably, I'd say, at least 30 days before they get it all completed. I'm sure we're not their only case. And so it may take a little bit.
all right. So what I'm going to do is I'm going to give it a 45-day reset so
Sounds
that
good.
we can see where we are. Miss Ferguson, can I have a 45-day reset on Jose Maria Cavassos III? And for the clerks, may I please have the file on Jose Marie Cavassos III? It's on the last page of the docket. All right, we'll be back on May 30th. Thank you.
Judge, just for the court's record, I am probably going to be out of town. That is my dad's 90th birthday.
Oh, well, you
So-
have to be there. We can move it further ahead.
If we can either move it a little ahead, a little further down the line, either way, whatever works for the court.
How long are you going to be with your,
His birthday's the 30th, so I'm probably coming home June 1st or 2nd. Be my
all right,
guest.
Miss Ferguson, can we put it in June? Because I don't know if Mr. McLean has already bought a gift for his father or not, or if he's a procrastinator with that. So we don't want to do it.
Your Honor, you know me well.
So we can put it in June, Miss Ferguson. All right, June 6th.
Perfect. Thank you so much, Judge. I appreciate you.
Sure. And Miss Ferguson, can you have the clerks bring that file to me, or either I will go be a clerk and grab it as well?
Judge, we only have one clerk right now, and he's getting that file for you. Just 1 second, Judge.
I don't know why that file wasn't included since it's on the docket sheet, but these are questions for another time. Thank you, Mr. McLean. Thank you, Mr. Wilkins.
Thank you, Judge. Appreciate it. Be excused.
Yes, you're excused.
Have a great day.
Thank you. Mr. Orta? All right, Mr. Orchard, we can't hear you. All right, Mr. Allen?
I need to confer with my client for a minute and then with the DA, and it should be ready.
Who is your client?
Christopher Robles.
All right, I'll send you to breakout room number 2. A prosecutor will meet you there. All right, Mr.
Thank you,
Allen, where is Mr. Villa? All right, he can come forward and take a seat. All right, the court is calling 2020 CR 1963, State of Texas versus Sammy Villa. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Matthew Allen.
And are you Sammy Villa?
Yes, ma'am.
All right. We're proceeding by video. However, the defense attorney, the defendant, and the state are in the courtroom. Any objections to us proceeding by video, state?
No objection.
Defense?
Judge, I didn't know if we were going to do it by video. Can I have a second to talk to?
Yes.
Mr. Whitaker? Thank you. Judge, after talking to Mr. Villa, we would object to doing it by video.
Well, the only thing that's going to be different is we're going to do it by video. I'm just going to be in the courtroom. So my understanding is that you no longer want me to be in my office. You want me in the courtroom. Is that correct, Mr. Villa?
Yes, Judge.
All right, I'll be there. Just give me a moment.
Thank you, Judge.
All right, to the court report, are you able to hear us?
What was that, Judge?
Are you able to hear us? All right, are you Sammy Villa? Are you the same Sammy Villa who was placed on deferred adjudication in cause number 2020 CR 1963 for the offense of aggravated assault with a deadly weapon on May 5th, 2020 for a period of 6 years? Is that you?
Yes, ma'am.
State.
Condition number 1, on or about the 31st day of August 2021 in Bexar County, Texas, the defendant Sammy Villa committed the offense of aggravated assault with a deadly weapon in violation of condition number 1.
How do you plead to that? True or not true?
Not true. Condition number 5, in Bexar County, Texas, the defendant Sammy Villa did and failed to report to the supervision officer as directed for the month of September 2021 in violation of condition number 5.
How do you plead to that? True or not true?
True. Condition number 26, on or about the 31st day of August 2021 in Bexar County, Texas, the defendant Sammy Villa did and failed to comply with the rules and regulations of the Bexar County Community Supervision and Corrections Department Intensive Supervision Gang Unit, and that the defendant committed a new offense in violation of condition number 26.
How do you plead to that? True or not true?
Not true.
All right. For the record, the defendant has pled true to condition number 5 and not true to conditions 1 and 26. Is that correct, defense?
Yes, Your Honor.
All right, state.
Judge, the state will call probation officer Annalise Abby-Rochette.
Probation.
I'm sorry, Judge, can you repeat that? I'm having trouble hearing.
All right, was that you, Ms. Benavides?
No, ma'am.
That was a CLO, Judge.
CLO.
Another CLO is being called as a witness.
Oh, I'm sorry, Judge.
That's okay. Can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record, please.
It's Annalise Abby-Rochette.
And could you spell your name, please?
First name is Analise. Last name Adirached.
All right, and I'm gonna need you to speak up so that the court reporter can hear.
And is there a way to get her on screen, Judge?
No, there is not.
I don't see her. Okay. Oh. Where did John go?
No, there's no way to get her on the screen.
Okay, hold on a second. Y'all just disappeared. I hear you, but I don't see you. Hold on a second.
Okay, sure.
Okay. Okay, Judge.
All right. Just state your name for the record again, please.
It's Annalise Abby-Rochette.
All right, I'm sorry, state.
Thank you, Judge. Annalise, how are you currently employed?
With Bexar County Probation.
How long have you been with Bexar County?
Over 6 years this year.
And are you a probation officer?
Correct.
Are you responsible for supervising individuals who are placed on probation?
Correct.
Were you responsible for the supervision of Sammy Villa under cause 2020 CR 1963?
Correct.
When did you become his probation officer?
I was assigned the case December 2nd of 2022, or 21, sorry.
And prior to that, did he have a different probation officer?
He did.
Would that previous probation officer have gone over the rules of probation, conditions of probation?
Objection, speculation.
All right, could you repeat the question, please?
Yes, would the previous probation officer have gone over the conditions of probation with Sammy Villa?
Yes.
Judge, objection, speculation.
That is sustained.
As when someone is placed on probation, is it part of, I guess, probation's normal practice of business to keep a file or record for that individual?
Yes.
And are you a custodian of records for the probation department?
Correct.
For the individual Sammy Villa under cause number 2020-1963, is there a file for that case?
Yes.
And is it a regular practice of probation to keep a file for an individual placed on probation?
Yes.
And the file for Sammy Villa, was it made at or near, I guess the events and everything that's recorded in the file, are they made at or near the time that the events occurred?
Correct.
And are they made by someone with personal knowledge of the events as they occur?
Yes.
Your Honor, at this time, we would offer the probation file as a business record.
Judge, we would object. She stated she got this file December 2nd of 2021. The allegations here predate that. This was actually filed October 14th of 2021. So I'm not sure how she would have personal knowledge or know that these records were accurate or made at the time, because she's not the one inputting them. And again, she didn't get the file until December 2021. Also, we haven't been tendered the file, so I don't.
Well, have you looked at, do you wish to see the file?
Yes, Judge.
Right.
And Judge, it's an electronic copy, so we would have to look at probations.
All right. All right, let's have a look at the file.
Scan it on, sorry.
All right, and defense, any objections?
Just the first objection, as far as that this witness wouldn't be the proper person since she wasn't there. Also, looking through the file, it looks like they have files for police reports, new police reports. So anything that is in there would be hearsay, so we'd object to hearsay and the right to confrontation on Mr. Villa's behalf. Also, there are documents that aren't going to be relevant to the two allegations that we pled not true to, so we'd also object to relevance.
State.
Judge, she has testified to the foundation to establish herself as a custodian of records, and that this file that is kept by her.
Sorry, State, can you?
She needs you to speak up, Mr. Sanders.
Yes, Judge, the witness has testified that she has met the foundation as a custodian of records for the Bexar County Probation Department. And she also has testified that the file that is kept for this cause number is kept in the normal course of business, is made in the normal course of business, that is made at or near the time of the events as they occur, and is made by someone with personal knowledge. She has hit all of the foundational requisites for a business records. Therefore, she should be able to testify as to what is in probation's file.
All right, defense's objection will be overruled.
And so, have you said that, when did you become this probation officer?
December 2nd of 2021.
Okay, and as part of the probation file, is there a picture of the individual who's placed on probation?
Correct.
And based on your review of the file, do you see that individual here in the courtroom today?
Yes.
Could you point to them and identify them by an article of clothing?
Wearing gray collared shirt and white tie.
Okay, and may the record reflect that the witness has identified the defendant. Whenever someone violates the condition of probation, do you generate, or does a probation officer generate a motion to revoke?
Yes, within 24 hours.
Is it a violation of someone's conditions to commit a new offense?
Yes.
Okay. And if that individual is placed in the, I guess, gang supervision, is that also a violation of condition number 26?
Correct.
Based on your review of the file, did Mr. Villa commit a new offense?
Objection goes straight to a legal matter, whether it committed a new offense, and all of her information is based on hearsay.
And Judge, I'll rephrase the question. Based on your,
His objection will be sustained. You can rephrase the question.
based on your review of the file, was Mr. Villa arrested for a new offense?
Yes,
What was that date?
August 31st of 2021.
And also, was a no contact order placed as a condition of his probation?
Objection, relevance.
Overrule.
Yes.
Yes, it was.
And who was that individual?
Katie Villa.
Governor, will pass the witness.
I'm sorry, I didn't get that name. Who is that individual? Yeah.
Katie Villa.
All right, defense.
Just a few questions. So obviously you were placed as Mr. Villa's probation officer December of 2021, is that right?
Correct.
And this motion to adjudicate was from October of 2021, is that right?
Correct.
Okay, so you don't have any personal knowledge of Mr. Villa prior to December of 2021?
I do not.
And you've actually never met Mr. Villa before, is that right?
Correct.
And any of the information that you testified to, that's just from you reading other people's work or documents, right?
Correct.
No further questions.
All right.
Just briefly, Judge, is it a practice of probation officers to go over the conditions with the defendant when they're placed on probation?
Yes.
And does the probation officer have that individual sign a copy of the conditions?
Yes.
Was there a signed copy of the conditions for Sammy Villa?
There is, yes.
Pass the witness, Judge.
No further questions.
All right, is this witness excused?
Yes, Judge.
All right, thank you. You're excused.
Thank you.
State, call your next witness.
The state calls Deputy Aldaco.
All right, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, and if you can make sure you speak up into the microphone, please. And if you could state your name for the record.
My name is Juan Aldaco.
All right, state.
Thank you, Judge. Deputy Aldaco, can you, how are you currently employed?
I'm a sheriff's deputy with the Bear County Sheriff's Office, assigned to East Patrol.
How long have you been with BCSO?
19 years.
Okay, so you were with BCSO back in 2021?
That's correct.
On August 31st of 2021, do you recall responding to 9551 Dunstable Drive?
Yes.
Do you remember what you were dispatched out there for?
For an injured adult.
What other details? Did you have any more specific details?
They informed us, dispatch informed me that a male was struck in the head with a hammer.
Okay, and so when you got to the scene, how many individuals were there?
2.
What were the names of those 2 individuals?
Right now, I just recall the last names, Cortinas, Mr. Cortinas and Mr. Ortiz.
Okay, does Billy Ortiz, does that sound right?
Yes, I believe it's Billy Joe Ortiz, yes.
And then that address to 9551 Dunstable, is that located here in Bear County, Texas?
Yes, sir.
And so when you got there, you said that Billy Ortiz and Mr. Cortinas were there.
That's right.
What, I guess, describe the location.
So when I arrived to the residence, I could tell the resident was under renovations. And construction building material on the outside, the door was wide open. As soon as I proceeded to the front door, I observed a pool of blood right at the entrance pathway. There's like a little hallway in the front. A pool of blood, and like I said, and 2 males. One was laying on the ground, injury to the head, and you had another male standing over him, applying pressure to his wound.
And Your Honor, may I approach the witness?
Yes.
Okay, I'm showing you what's been marked as State's Exhibits 1 through 9. Can you look at those and tell me if you recognize them?
That is correct. I do recognize these pictures.
Are they fair and accurate depictions of the scene on that date?
Yes, sir.
Your Honor, at this time, State offers State's Exhibits 1 through 9.
No objections, Your Honor.
All right, State's Exhibits number 1 through 9 are admitted into evidence.
Your Honor, may I submit them to the court?
Yes.
So Deputy Agassi, you said that there was a pool of blood on the ground and there were 2 individuals, one laying down.
Yes.
Did you attempt to speak to the individual who was laying on the ground?
Yes, I asked him for his name, date of birth, which he was able to provide.
Okay.
And that's pretty much he was able to give me. After that, he was just moaning. Every time I asked him a question, so I directed my question to the witness that was there.
Okay, and the injury that, who was the one laying on the ground?
Mr. Ortiz.
Okay. Where was the injury that he had?
To the left side of his head.
Towards the front or the back, if you recall?
I can't recall exactly. I'm pretty sure more kind of more center. Yeah.
And so you spoke to the witness at the scene. I guess, was the person who they said was responsible, was he at the scene when you arrived?
No.
Okay.
He was not there.
Just those 2 individuals?
Yes.
All right, at this time, we'll pass the witness.
All right, defense.
Deputy, again, you got there after the fact, right?
Yes, sir.
Okay, so, and then you said the individual, Mr. Ortiz, was able to give you his name and date of birth?
Yes.
And then no other information?
No other information.
And the scene, you described it as, it was undergoing renovations?
That's correct.
And so there was, as far as the renovations, there was construction tools and other things that were helping with that renovation?
Yes.
No further questions.
All right, is this witness excused?
Yes, Judge.
Defense?
Yes, Judge.
Okay, you're excused.
Thank you.
All right, defense, I'm sorry, State, call your next witness.
The state calls Investigator Villar.
All right, you raise your right hand for me, please.
Yes,
Do you
Judge.
solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
That's right.
All right, if you can have a seat, please. And your answer is yes or no to telling the truth.
It's yes, Judge.
All right, thank you. If you could state your name for the record, please.
My name is Michael, last name's Beyond.
All right, state.
Thank you, Judge. Investigator, how are you currently employed?
I'm with the Bexar County Sheriff's Office. I'm assigned to the Criminal Investigations Divisions for Bexar County.
Okay, how long have you been with Bexar County?
9 years.
How long have you been with CID?
6 months.
Would you have been with CID back in August of 2021?
Yes, sir.
When you're an investigator in CID, do you respond out to the scene for certain offenses?
Yes, sir.
What types of offenses do you respond to?
Can be violent crime, sexual assaults, deaths that occur unnatural.
Okay, usually felony offenses?
Sir.
On August 31st of 2021, did you respond to 9551 for an aggravated assault?
Sir, yes, I did.
When you made the scene, do you remember how many individuals were there?
One,
Who was that one?
Cordenas.
Where was there a victim?
No, there wasn't.
Do you know where the victim was?
He got transported to the hospital for his injuries.
And what about a suspect?
There was no suspect on site. The person took off.
Okay. And so, did you look at the scene?
Yes, I did.
Did you, I guess Deputy Docket testified that there was a lot of blood and there's been some pictures of it. Did you see, I guess, the crime scene that had blood everywhere?
Yes.
Did you ever find a weapon?
There was none recovered. No, sir.
Other than, I guess, speaking to the one witness at the scene, what else did you do as part of your investigation?
Objection, calls for hearsay.
Overrule.
What else did you do as part of your investigation?
I tried to talk to the person who hired the two individuals, and then I went to the hospital to interview Billy, and I was unable to.
Okay, and Billy, do you remember Billy's last name?
Ortiz.
And he was the victim in the case?
Yes, sir.
And why were you unable to interview him?
Because he was undergoing surgery first day or that day.
Did you attempt another day to interview him?
Yes, I did.
What day was that?
The next day.
And how did your interview with Billy go that day?
It was difficult to understand him. It seemed like he was delayed in his speech. His motor functions were delayed. He was extremely frustrated because he couldn't get out what he wanted to say or what he wanted to tell me. And it seemed like there's parts in his memory where he can remember what took place, but he did remember he was struck behind the head with a hammer.
And were you informed of where he was struck?
Behind his head.
Towards the back of his head?
Correct.
At some point, was a photo lineup done in this case?
Yes, there was.
And was Billy able to identify the individual who hit him with the hammer?
Yes.
Judge, objection, calls for hearsay. I don't believe Mr. Investigator Detective VR was the one that actually did any lineup. So he would have no knowledge.
Judge, I can ask some more questions.
All right, thank you. Then defense's objection will be sustained.
As an investigator assigned to the case, are you responsible for collecting all of the evidence for that case?
Yes.
And at some point, did you direct an investigator to do a photo lineup?
Yes.
Would you have collected that and submitted it as part of your prosecution guide?
Yes.
And at some point, did you issue an arrest warrant for an individual?
Yes.
Was that arrest warrant you issued based on a positive photo lineup?
Objection, again, calls for hearsay based on someone else's work.
All right, with regards to it being based on a positive lineup, that will be sustained.
At some point, did you issue an arrest warrant for an individual?
Yes, sir.
What was the name of that individual?
Sammy Villa.
At the time that you met with Billy Ortiz in the hospital, was he able to give you the name of Sammy Villa?
Yes, sir.
All right, this time we'll pass the witness.
Defense.
And I'm sorry, is it detective or investigator?
Whatever you prefer, sir. It's the same terminology.
Okay, I just want to get it right. I'm sorry.
Yes, sir.
So, Detective VR, again, you stated when you talked to Mr. Ortiz, he was unable to really give you much information as far as what happened. Is that right?
Yes, sir.
And you notate that the building that you went to or house that you went to was under construction or under renovation. There was lots of materials around.
Yes.
Would you agree with me that in an investigation, it's important to talk to all witnesses?
Yes.
And it's beneficial to try to talk to, I guess, both sides to get the full story. Is that right?
And this person who was in question left the location for me to question.
Right. So,
yes.
But you would agree with me that it would be important to try to talk to both sides?
Sure. Yes.
Because that can change your determination, right?
That's right.
No further questions.
All right, state, any follow-up?
No, Judge.
All right, is this witness excused or subject to recall?
Excuse for the state.
Defense.
I would ask, just subject to recall, I believe the next witness is gonna be the complainant, just in case.
All right, just make sure that you're remain available.
Yes, Judge.
All right, I'm sorry, state, call your next witness. It's been a long day.
The state calls Billy Ortiz.
All right, Billy Ortiz. All right, you'll take the witness stand, please. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, have a seat and make sure that you speak loudly into the microphone. Could you state your name, please?
Billy Ortiz.
All right, state.
Thank you, Judge. Billy, you're aware of why we're here today, right?
Yes, sir.
Okay. On August 31st, 2021, were you injured?
Yes, sir.
What were you, I guess, do you remember the location that you were at that day?
I just remember we were in O'Connor area.
Okay. What were you doing there?
We were renovating the house.
Who were you there with?
The workers, the boss.
Who was the boss?
Yeah, Josh.
Josh, do you remember his last name?
Cardenas, I think it was.
Okay, if someone testified Cortinas, does that sound?
Yeah, that's it.
Okay, and what work were you doing there?
Just renovating, taking flow, like, making it brand new.
What other people were there?
I didn't understand.
It was,
Just 1 second.
And what were you doing there? Just renovating? And then I didn't catch.
I didn't even see that.
Okay, here's the thing. I'm gonna need you to make sure that you speak into the microphone and make sure you speak loudly because the court reporter is by Zoom. All right, so which part do you need repeated, Ms. Benavides?
So the question was, okay, and what work were you doing there? And then he answers, just renovating, if he can continue from there.
I was renovating, taking, flowing, taking, I got a speech impediment. I can explain things like,
no,
it takes a while for me to explain things because I have a speech impediment.
No, this is the issue. It's not a matter of your explaining things. She just needs you to speak loud.
I understand that. I'm just saying, I'm trying to tell her, but the words are in my mind, but they're not coming out.
Okay.
But it's just hard to explain things.
All right.
Got it. Take a float. I got it. Take a float.
She heard you. Take a float.
Yeah.
Okay. Stay.
Billy, what other workers were there with you?
It was me, Josh, Sammy, Stanley, and Jay.
Okay. Sammy Villa?
Yes, sir.
Do you see him in the courtroom today?
Yes, sir.
Can you point to him and identify an article of clothing?
He's wearing a baby blue tie or white tie.
And so did you know Sammy Villa before that day?
Before that day, we worked together for like maybe 2 weeks.
Okay. Had you had any issues with him before that day? At some point, did you get into an altercation or argument with him?
That day, yes.
What was the argument about?
Him not performing actively with his work. So I called him out on it and he took offense to it.
Okay, so you felt like he wasn't working hard enough?
Yes, sir.
And so he got angry when you called him out?
Yes, sir.
Did y'all actually have any physical?
No, sir.
He just had the hammer in his hand while we were like arguing and stuff and pump faking it to me like he was gonna hit me with it.
Okay, so while you were arguing, he had a hammer in his hand?
Yes, sir.
And he was holding it up like he was gonna hit you?
Yes, sir.
Did he hit you at that time while you were arguing?
No, he waited till my back was turned and he.
Okay, so when did you turn your back?
Right when they were sending us back to work.
Okay, so from your perspective, the argument was done?
Yeah.
And you turned around?
Yeah, because I assumed he wasn't gonna do nothing. You know what I mean? So I went back to work, and when as soon as I turned my back, he slammed me with it.
So did you actually see Sammy hit you with a hammer?
No, but I saw Sammy with the hammer in his hand.
Were you arguing with anyone else that day?
No.
Who else was around when you were arguing with Sammy?
Everybody. They wanted to see us fight.
Okay. And so you felt that, I guess you turned around, and then what happened next? What do you remember?
Nothing.
Do you remember feeling any pain at that time?
I remember feeling like I was asleep forever.
Okay. What's the next thing that you remember?
I woke up in the hospital.
What injuries did you have as a result of being hit with a hammer?
64 sutures and 32 stitches and a metal plate in my head.
Did you have a metal plate in your head prior to the?
No, sir. I was perfectly fine.
As far as your speech impediment that you mentioned, did you have that prior to being hit with a hammer?
No, sir.
And you said that you have issues, I guess, getting thoughts out?
Yeah.
Was that an issue prior?
No, sir.
Are you able to work currently?
I have not worked since the day it happened.
Did being hit with a hammer change your life?
You have no idea, man.
Your Honor, at this time, we'll pass the witness.
Defense. Thank you. Mr. Ortiz, so the other individuals that were there, you said there was a person named Josh, right?
Yes, my boss.
And Stanley?
Yeah.
And the last
Jay.
name? Jay?
Jay.
Okay, and you said all those individuals were right there when it happened?
Yeah, they did as soon as it happened. They were left.
Well, so I'm asking, right when you're hit in the head, your testimony is that those individuals are right there when it happened.
Yeah, they wanted to see us fight.
Okay. When did you tell the prosecutor that prior to this, that Stanley and Jay were right there when it happened, that they'd be witnesses?
I mean, they're witnesses, but they're not going to get involved.
That wasn't my question. My question was, did you tell the prosecutor before today?
Who's a prosecutor?
Mr. Sanders.
Okay.
Or anyone from the DA's office before today, that Stanley and Jay were eyewitnesses to what happened?
Yeah.
You did?
Yeah.
When?
They were there.
Okay, when did you tell them that?
I don't know. I don't remember.
Was it in a phone call but it was before today?
Yeah.
Okay, because I guess, can we either approach or I just make an oral?
What is the motion?
It's not so much a motion, just that, Judge, at this time, I'd ask for any notes from the state has with interviews with Mr. Ortiz. This is the first time we're hearing that there were two other eyewitnesses, Stanley and Jay.
I was at the first time because he was there.
Excuse me.
And so I would like the notes to be able to see what exactly was said, because we're getting a new story with two eyewitnesses today that we didn't know before.
Judge, I do not have any notes from my meeting with Mr. Ortiz. If he says that he told me about it, Jay, I mean, I won't say that he didn't. I don't recall it. Stanley is mentioned in the police report, so defense was well aware that there were other people who were there. They are named in the office report.
All right, defense, ask your next question.
And Judge, just at this time, the Stanley is reported to be in the house, not an eyewitness to it. The first time that we're hearing Jay, so we would have to ask for a continuance to try to get Stanley and or Jay to investigate what their statements would be.
That's denied. You can ask your next question.
You said you knew Sammy about 2 weeks prior to this?
Yeah.
Okay. And actually, let me go back. Josh, where was Josh?
He was in the middle of us. He was in the middle of between us, trying to separate us.
Okay, so he's actually in between you and Sammy, is that right?
Yeah.
And then you turn around, right?
As soon as I turned around.
Okay, and then you're hit in the head.
That's all I remember.
Okay, so you don't know who actually hit you. Is that
He
right?
did. Bro, he had the hammer in his hand. Nobody else had a hammer in their hand.
Okay, but there's somebody in between you.
Yeah, my
Sammy.
boss.
Stop. So here's the thing. The court reporter is taking a record. She can only take the record from one person at a time. So this is how this is gonna happen. The defense will ask the question. You will be allowed to answer the question. Once you finish answering the question, the defense may have another question for you.
Okay.
All right. Defense, what is your question?
Josh is between you and Sammy during this time, right?
Mm-hmm.
And you turn around so you can't see behind you. Is that right?
Mm-hmm.
Okay. So as far as what happens behind you, you don't know for sure what happens behind you.
But
correct?
the instant I turn around, it happens.
I'm asking, you can't see behind you, right?
No.
Okay. And do you remember, as far as being at the hospital, making a statement, a guy named Josh was talking shit?
Josh?
Yeah. You remember that?
Mm-hmm.
Okay. Do you remember giving a statement at the hospital?
No, I don't even remember. All I remember is when they woke me up.
Okay. So you guys are both arguing with each other over Sammy's work. Is that right?
Mm-hmm. And he was drunk.
And his what?
And he was drunk.
He was drunk. Okay. Did you mention that to the state before that Sammy was
It's,
drunk?
it's in there, man. It's in there.
You told them about
Yes.
it, right?
Yes.
Okay. And you said that he had a hammer and was pump faking. Is that
Yeah.
right?
Yes.
Did you mention that to the state?
Yes.
Okay. And you actually have a couple felony convictions yourself, is that right?
Yeah.
You were on probation for kidnapping
Yes, sir.
and aggravated sexual assault of a child.
Yes, sir.
And then you had a theft case where a misdemeanor theft case, you served some jail time, is that right?
Yes, sir.
Judge, I don't have any further questions at this time. I would just make a renewed request for any notes, not only from the prosecutor, but from the DA's office. I can go through what the new information is that I'm getting, that Mr. Ortiz said that he allegedly told the state prior to this, which includes 404B of Mr. Vita being drunk, new allegations to the incident, and new witnesses. And so I would request those notes so I can review them.
All right. So which part of the testimony is the state to believe from the complaining witness? Are you saying that what he's saying about the information he told the state is true, but everything else is not true?
Not necessarily true or not true. I'm getting new information from Mr. Ortiz that was not previously disclosed to me.
Okay.
And Mr. Ortiz, I'm sorry.
No, go ahead.
And Mr. Ortiz is saying that he had previously disclosed that to the state.
Judge, my response will be that all of that information, other than the witness Jay being there, was disclosed to defense. Prior to, at our last sitting, Mr. Allen and I were conferring on the case outside, he asked me, why did the argument happen? I went and asked Billy, why did the argument happen? And he told me that it was because of, he didn't feel that he was working and because he felt like he just was drinking all the time. And so me and Mr. Allen had a discussion about that outside of the courtroom, as well as the fact that he said that Sammy Villa had a hammer in his hand and that Sammy hit him with a hammer. Because I remember discussing with Mr. Allen that I then asked Mr. Ortiz that he didn't know that because he doesn't have eyes on, he couldn't have seen that. So all of that was disclosed to Mr. Allen and the defense, except for the part about this possible witness, Jay.
All right. So, defense and state is saying that they do not have notes.
And I guess if we could just get that on the record, that there are no notes from the prosecutor or any member of the prosecution team.
Correct, there are no notes.
Any further questions for this witness, or is he excused?
No, no further questions.
Is he
No further
excused?
questions, Judge.
All right, thank you. You can
Thank
sit
you.
down. State, call your next witness.
No further witnesses, Judge.
Defense?
Can I have just 1 minute, Judge?
Yes.
Thank you.
Thanks. All right, Ms. Benavides, while the defense is discussing something with this client, are you okay to take another matter?
Yes.
All right, who are the parties on Enrique McGraw?
State judge.
Who's the attorney?
Roundtree.
Tim Roundtree?
Judge.
Hello. All right, the court is calling 2022 CR 2124, State of Texas versus Enrique McGraw II. Have parties announced for the record for the state,
Jory Garcia.
for the defense.
Tim Roundtree.
And are you Mr. McGraw?
Yes.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. McGraw, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. On the entry by the clerks, I have that there's no application, but there's an application in the file. So is he applying or is he not applying?
We are not applying, Judge. That was just, there was no way to complete the paperwork without signing that.
All right. Mr. Roundtree, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. McGraw, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
State moves to waive the repeater enhancement paragraph on the indictment.
Any objections?
No, Your Honor.
Mr. McGraw, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand what you're charged with is driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. McGraw, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is waiving the repeater enhancement allegation. They're asking that your punishment be assessed at 3 years in the prison. There's a $1,500 fine. There are no applications, and this is the rank concurrent with 2016 CR 8081. Did you understand that to be the plea bargain agreement?
Yes,
The
Your Honor.
judge, there is, the agreement is for 2 years. That was reached after the paperwork was generated. So we would ask that you would change that to a 2-year TDC offer.
Is that correct, state?
That's right, Judge, yes.
All right, then they're asking for 2 years in prison. Did you understand that to be the plea bargain agreement, Mr. McGraw?
Yes, Your Honor.
All right, and this cause number, the 2016 CR 8081, is that parole?
Yes, Your Honor.
Mr. Roundtree, is that the parole case number?
It is not the parole case number, Judge, but I believe that's the case number that he is in the state court that he is on parole for. I don't know what a parole number is, Judge.
Okay, so, Mr. Roundtree, has he already been revoked?
He has
by
not been
parole?
revoked. He has not
All
been
right, so
revoked.
Mr. McGraw, do you understand that the court has no jurisdiction to force the parole to run currently? Do you understand that?
Yes, Your Honor.
All right, Mr. Roundtree, did you understand that to be the entirety of the agreement?
There is a misdemeanor case that will be dismissed, Judge, as well, on evading arrest.
All right, is that a part of the plea bargain agreement?
Yes, Judge.
What's the cause number?
That cause number is 674-450.
I'm sorry, 674?
450.
All right, so let me try this again after I've made all of the corrections. All right, the state, according to the plea bargain agreement, Mr. McGraw, the state is waiving the repeat enhancement allegation. Punishment is to be assessed at 2 years in the prison. There's a $1,500 fine. There are no applications. This is running concurrent with 2016 CR 8081, which you understand the court has no jurisdiction to force parole to run these cases concurrently. Did you understand that?
Yes, Your Honor.
And the state is going to dismiss cause number 674-451. Did you understand that to be the entirety of the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement.
Yes, Judge. We may need to pause, Judge. I am a bit confused as far as running concurrent with parole. My understanding is that as long as you don't stack the sentences, that all sentences run at the same time.
No, they do not. I have no jurisdiction to force parole to run this concurrently. It's similar if he has a federal case and the federal case hasn't been heard I can say all I want, this case is to run concurrent with that, but federal doesn't have to do that. So I can't force parole. If parole decides to revoke him and he's revoked on his parole, then I can't force them to run this concurrently.
Well, Judge, I would like, if we could then take a break on this and let me confer with my client and just make sure that he fully understands. And we may have to come back on another day just so I can do some research, Judge, if that's okay with the court. I believe we're going to accept the agreement.
With your client.
Yeah. And Judge, could I speak with Mr. Garcia as well, briefly, before I speak to my client?
All right, Mr. Garcia, you have the ability to move Mr. Roundtree throughout the breakout rooms.
Judge, I'm not a co-host at this time. Okay, Brittany's moving. That's thank you.
You're welcome. All right, we're back on the record. Mr. Allen, we're back on the record in 2020 CR 1963. The state has rested, Mr. Allen.
Yes, sir. We call it Sammy Villa.
All right, Mr. Villa, you'll take the witness stand. Raise your right hand. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, take a seat. State your name for record, please.
My name is Sammy Villa.
All right, make sure you speak into the microphone. Defense.
Thank you, Judge. Mr. Villa, you pled, just to get it out of the way, you pled true that you did not report in September of 2021. Is that right?
Yes, sir.
Why didn't you report?
I was scared.
And we'll get into that. So that is true. You did not report in September of 2021.
Yes, sir.
Let's go to the day in question. What were you doing that day?
What was
The date that Mr. Ortiz just testified about. What were you doing that day?
that day? I was drinking in She-Rock and I had made a comment towards another guy playing around. And Ms. Ortiz had told me.
I need you to speak up. The court reporter cannot hear. All right, so that's the microphone.
Are you a little bit nervous, Sammy?
Yes, sir.
Okay, I'm gonna ask you a question. Just answer that question, okay?
Yes, sir.
All right. So on that day, were you working?
Yes, sir.
And what kind of work were you doing on that day?
Home renovation.
And who else was there with you?
I'm sorry, I didn't understand that answer. What kind of work were you doing that day? And he answered.
Home renovation.
Home renovation. Okay, thank you.
And who else was there that day?
It was me, Joshua, Billy Ortiz, and that was when the incident happened. But earlier during the day, there was two other guys that were there.
Do you know their names?
I know one of them was Stanley, the other one I don't know his name because he just started working.
Okay. How long had you known Mr. Ortiz prior to that day?
He was working with us for about a month.
Okay. And did on that day, did you and Mr. Ortiz have a verbal disagreement?
Yes, sir.
How did that start?
I had made a comment towards another guy, and then Billy had made a threat towards me saying that I was always saying.
Objection, hearsay.
Sustained.
Okay, so you made a comment towards another coworker?
Yes, sir.
Okay, and then Billy says something to you?
Yes, sir.
Okay, and what does he say?
Objection, hearsay.
Judge, if Mr. Villa can answer, it goes against the interests of Mr. Ortiz, plus we'd argue as a party opponent. It's a statement against interest.
Who is?
Mr. Ortiz, the complainant.
Yes, that'll be sustained.
When Mr. Ortiz without saying what he said, when he's making these comments, what is his demeanor like?
He was posing a threat towards me though, when everything was going on.
And was he raising his voice?
Yes, sir.
Was he excited?
He was raising his voice and he was jumping around.
Judge, at this time, I asked that I be able to ask that question. It would be an excited utterance and a statement against interest for Mr. Ortiz.
State,
Judge, I don't believe that he's met the foundation requirements for an excited utterance exception hearsay.
all right, and which part do you believe he has not met the requirements of?
One second, Judge. Judge, my response would be that he hasn't established that Mr. Ortiz's statements were made in such a state that would go to their, I guess, reliability as an exception hearsay. I guess my additional objection would be, that's it, Judge.
All right, that'll be helpful. You can answer the question.
All right. So what did this?
I'm sorry. I didn't get the last word. Additional objection would be the very last word you said, Mr. Sanders?
That would be it, Judge.
Okay.
You can ask the question.
Mr. Villa, what did Billy say to you?
He had told me to think about my kids before he did something sexual to me.
And at this point, you and Mr. Ortiz are engaging in a verbal disagreement.
Yes, sir.
Does Mr. Ortiz say anything else to you?
He just kept making threats saying go outside and he had a knife in his hand.
Go outside and what? Go outside and what?
He was telling me to go outside, making threats towards me with a knife in his hand.
Now to be clear, was he saying he had a knife in his hand, or did you see something?
I saw the knife in his hand.
Okay. And where in conjunction to the door is Mr. Ortiz closer to the door, or are you closer to the door?
Mr. Ortiz was.
Okay. Is there anywhere for you to go without going past Mr. Ortiz?
No, sir.
And in this room at the time, who's in that direct room with you and Mr. Ortiz? Anyone?
Me and just him.
Okay, so there's no other people standing right there?
No, sir.
Okay. And now does this, eventually it turns into a physical altercation? Is that right?
Yes, sir.
How does that happen?
He kept making the threats over and over, and then he started making hand gestures.
What kind of hand gestures?
He was doing just sexual hand gestures, grabbing himself and saying things he was gonna do over and over.
Does he?
I'm sorry, just sexual hand gestures and saying what?
He was making sexual hand gestures and saying the same thing when he was gonna do to my children over and over.
Does he come closer to you at any point?
Yes, sir.
Okay. How far are you guys away when you first start arguing? How many feet?
About 15 feet.
Okay. From me to you or closer?
About from me to you when he first made the first threat.
Okay. And then at some point, does he come closer to you?
Yes, sir.
How close does he get to you?
The closest he got was less than 5 feet.
And at that point, what are you thinking when he's approaching you?
I was just getting scared because I saw he had a knife in his hand.
And so what do you think that he might do?
I thought he was gonna stab me.
And so when he gets close to you, what is your reaction? What do you do?
I grabbed the hammer.
Okay. Did you have the hammer when you guys were first arguing?
No, sir.
What hand do you write with? What hand do you use?
Right hand, sir.
Okay, so you're right hand dominant.
Yes, sir.
What hand do you grab the hammer with?
Well, I grabbed it with my right hand and put it and keep it right there.
Okay. And so he approaches you and you think that he's gonna stab you.
Yes, sir.
Or attack you. Are you scared at that point?
Yes, sir.
What do you do eventually with the hammer?
I ended up swinging it because he swung the knife at me.
And you swing it with your right hand?
Yes, sir.
So you would hit him on his left side.
I didn't see where I had hit him. I had jumped back because he swung the blade at me.
Okay. After you hit him, what do you do?
That's when Joshua ran from the back room and Joshua Cortina said something to leave. That he told me to leave. I was never there.
Okay. And you did leave, right?
Yes, sir.
You didn't call police
No, sir.
and you didn't make any police report, is that right?
No, sir.
Okay. Was that a mistake?
Yes, sir.
Were you scared at that time?
Yes, sir.
I'll pass the witness. State.
Thank you, Judge. Mr. Villa, so you didn't call the police after
No,
you
sir.
were,
No, sir. I was scared.
you were scared of what?
I was scared to call the police
Why?
because I was on probation. I didn't know what to do.
So were you aware that it's a violation of your probation to pick up a new criminal offense?
Yes, sir.
And also did not report to your probation officer, right?
Yes, sir.
You've been on probation before, correct?
Yes, sir.
And you were revoked from that probation?
Yes, sir.
You were convicted of robbery before?
Yes, sir.
And you also have a history of violence, correct?
Yes, sir.
You have a prior conviction for assault choking,
Yes, sir.
and you're currently on probation for aggravated assault, isn't that correct?
Yes, sir.
And so on this day, August 31st, 2021, you're saying that you were attacked by,
Mr. Ortiz.
okay. And so even though you felt that you were in the right for defending yourself, you still didn't think it was appropriate for you to call 911.
I was scared.
Okay, and so you also didn't think it was appropriate for you to report to your probation officer for the next month, right?
I was scared. I didn't report because I saw myself on TV.
Okay, and so you couldn't even place a phone call to your probation officer?
When I had tried to call, nobody was answering, and then I had said that to several voicemails.
Okay, have you said that to anyone before?
Yes, sir.
Who did you tell that to?
I had told everyone that probation wanted to go see me.
In the jail?
Yes, sir.
Okay, and so you didn't call 911 and you didn't attempt to get in contact with your probation officer. When did you, I guess, are you saying you attempted to get in contact with your probation officer?
About 2 weeks later, I had tried to contact her and there was no answer. I was leaving voice. I left the total of 3 voicemails and she responded back to me.
Okay, did you make any additional attempts to contact them?
No, sir, but I had tried several attempts to turn myself in with a non-emergency.
Sorry, you attempted to turn yourself in how?
With the non-emergency, the police number.
Okay, did you ever attempt to just go to a substation and let them know that you had a warrant?
No, sir.
Okay, and so I guess your version is that Billy lunged at you with a knife, you jumped back and hit him.
Yes, sir.
Did you hear the testimony from the witnesses that Billy was struck in the back of his head?
No, sir.
Okay. Did you hear the testimony that it was the top back of his head?
I heard it, but I never knew what was going on.
Okay. And so how did you swing? What motion did you swing with?
I don't remember.
Okay. Would you agree with me that it's difficult to hit someone in the top back of their head if you're in front of them, facing them?
Yes, sir.
All right, at this time, we'll pass the witness.
Defense.
No further questions.
All right, thank you. You can step down. Defense, call your next witness. All
The defense rests.
right, state, any rebuttal?
No, Your Honor.
All right, state, you close,
Yes, Your Honor.
and defense, you close.
Yes, Your Honor.
All right, the court will hear argument. State.
Judge, we proven violation of condition number 1.
Sorry, I'm not hearing you that well, Mr. Sanders.
You can remain seated. Yes.
Okay, Judge, we have proven violation of condition number 1. You heard testimony from the detective as well as Billy that Billy suffered an injury to the top back of his head. You also heard testimony from the deputy, the detective, and the defendant himself that he was not at the scene, that he fled, that the individual who was at the scene was a Mr. Cortinas, the person who defense, I guess, is sort of implying may have been the one who committed the offense. Billy testified that he was arguing with the defendant right before, that the defendant had a hammer in his hand and was threatening to hit him, that he turned around and that's when he was hit in the back of the head. It's consistent with the injuries that he suffered. His Billy's version of the events is consistent with the injuries that he suffered, as well as the defendant's behavior after the offense is consistent with Billy's version of how it happened. Additionally, the defendant is on probation. He was well aware of the consequences of failing to report and failing to inform, I guess, take the appropriate action, and he still fled from the scene. Because he committed the new offense, that is also a violation of condition number 26, and so we feel that we have proven that he violated condition number 1, as well as condition number 26, that the defendant struck Billy Ortiz with a hammer, which is a deadly weapon capable of causing serious bodily injury, and it did, based on Billy's testimony, that he has a metal plate, as well as all of the stitches and sutures that he suffered, and the physical and mental impairment that he now suffers from.
All right, defense?
Yes, Your Honor. As far as the testimony from any officers, obviously they weren't there. They don't know what happened. The detective did state that it would be important to get both sides of the story. There's no testimony that they ever tried to contact Mr. Villa for his side of the story. And obviously that does change things. As for Mr. Ortiz, he doesn't remember giving a statement at the hospital. He gives at least a few different statements, I believe, to the state and here today. He names 3 eyewitnesses that are somehow not here, that aren't testifying that Mr. Villa viciously assaulted him, as he says. As far as his version, it doesn't match the physical evidence because Mr. Villa is right-handed. He picked up a hammer with the right hand, which most people would pick up with their dominant hand. If you hit somebody on that side, if they're facing you, you're going to hit them on the left side, not if they turn around. Then either someone has to hit you with their left hand or come around.
Oh, Mr. Allen, if you could remain seated so that it's easier for the court reporter to hear, because that's the microphone. No, I understand that a lot of times we're taught to always stand up, but it's easier for her to hear if everyone's seated.
Yes, Judge. So the physical evidence doesn't match Mr. Ortiz's statement. We don't believe that they have proven that Mr. Villa committed an aggravated assault with a deadly weapon or committed a new offense, because he was acting in self-defense to the threats that Mr. Villa said, as well as Mr. Ortiz approaching with a weapon. We heard testimony that there was, in this construction scene, that there were construction materials and tools around. And again, as far as condition number 5, Mr. Villa readily admits that he did not report. He did make mistakes on that day. Just because someone told him to leave, he should not have left. He should have turned himself in. And calling probation is not an excuse. He needed to report to probation. He knows that. He pled true to that. And again, we readily admit that. But we would argue that condition number 1 and number 26, that those violations were not proven on this day.
All right, court is finding violations 1, 5, and 26 true. State, what are you requesting?
Judge, we're asking that you revoke his probation and sentence him to the maximum, based on the fact that he's on for an aggravated assault. He picks up a new aggravated assault as well as his prior convictions for violence.
Defense?
Judge, we have 2 letters here we'd ask to be submitted. the parties are not here to testify today.
Are you asking if they be admitted
Yes.
into evidence?
Yes, Your Honor.
All right, state any objections?
Yes, Judge, we would object to hearsay.
That would be sustained.
Understood, Your Honor. Okay, Judge, then I'll just have argument.
Oh, please remain seated.
Oh, I'm sorry.
That's okay. It took a while for me to remember to do that as well.
I haven't been doing very many live things, so. As far as what we would be asking, I mean, Mr. Villa wants to remain on some type of probation or deferred. I understand the court has found that he violated the conditions 1, 5, and 26. So if Mr. Villa were not to be allowed on deferred, I don't think a sentence of 20 years would be needed. We'd ask for something lower as far as 5 years. Mr. Villa did spend 6 months in jail. He just recently bonded out about a week ago. So he was booked in October, and like I said, just bonded out. He's been on GPS. I know it's a short time, but he has not had violations while he's been out. He does have 5 kids, a grandmother and a mother that he takes care of. He is the breadwinner of the family. Any sort of prison time, the 6 months that he spent, devastated his family, financially, emotionally. Obviously, Mr. Villa understands that it's his responsibility to follow those conditions and rules. But again, just based on that information, we would ask the court to take that into consideration. And again, I don't believe that the maximum would be needed in this case to ensure justice or law and order in the community. That's something more along the lines of 5 years would be appropriate.
Judge, I guess at this time, I would ask to reopen evidence to call a witness.
For what purpose and
For
why are you
punishment
asking
purposes.
to reopen?
For punishment purposes, Mr. Allen stated that Mr. Villa is the breadwinner and sort of references that he has a family to take care of. The state would like to call Katie Villa, who is here present in the courtroom, who the defendant has a no contact order with, but for purposes of showing that Mr. Villa has violated the court's orders and the risk that he is to the victim in the case.
Judge, I don't see any reason the state argued and rest. I don't see any reason to reopen that. Mr. Villa does have 5 kids. He has to provide for them financially.
All right, so here's the question. Is there a no contact order in this case with the person that has been mentioned by the state?
There is in the deferred the 2020 CR 1963, I believe there is a condition.
Which is the case that we're here for today?
Correct, Judge.
All right, and is that the person who's at the back of the room or?
Judge, I'm not gonna.
Yeah, is that the person who perhaps drove Mr. Villa here?
Yes, Judge.
I do not know who drove Mr. Villa here, but again, I'm not gonna answer. With respect to the court, I'm not gonna answer questions.
Yeah, I understand. Person who's at the back of the room. I'm sorry, I can't see her. All right.
Yes, ma'am.
All right, thank you. I don't have any questions. I can't see over the computer.
Yes, ma'am.
All right, thank you so much for coming. All right, I'm not gonna allow the state to call the witness. Both parties have rested and closed. Any rebuttal with regards to Mr. Allen's closing state?
Judge, just that he's proven that he's not a good probationer. This is his second attempt at probation. And again, like I said, he's on for aggravated assault, and I feel like the worst thing that he could have done is to go off and commit another aggravated assault. He's a danger to not only the victim in the new case, but also in the old case, as well as the community as a whole. He's shown to the court that he doesn't deserve to be out in public.
All right, the court is finding the defendant guilty. The court is going to find an affirmative finding of family violence, an affirmative finding of a deadly weapon. Court will sentence you to 15 years in the prison. Give you credit for any time served. And I'm sorry, I need the trial court certification. I'll check the box. Thank you. No problem. All right, Mr. Miller, did you review the document with your attorney entitled Trial Court Certification and Defendant's Rights to Appeal?
Yes, ma'am.
All right. This is not a plea bargaining case, so you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not that you are in deferred adjudication. Do you understand? And because this is an affirmative finding of a deadly weapon and an affirmative finding of family violence, I'm sorry, because this is an affirmative finding of family violence, and because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you need to contact an attorney. Do you understand?
Yes, Your Honor.
All right, Mr. Allen.
And Judge, just to be clear, you're not making a affirmative finding of deadly weapon?
No, I did state that on the record. I stated it when he was sentenced.
Okay, thank you, Judge. I missed.
No problem. Is that correct, Mrs. Benavides? I did state that on the record that there was an affirmative finding of deadly weapon and an affirmative finding of family violence when Mr. Bill was sentenced.
You did, Judge.
Okay, all right, thank you.
Yes, you did, Judge.
All right, thank you. All right, are we ready on Enrique McGraw?
Judge, I am ready to approach. I would ask that you would, I anticipate we're still accepting this plea agreement, but I need to accurately advise my client. I would ask that you would give us a week or two for me to do the research I need to make sure I understand. And then we'll be back.
Ms. Ferguson, on Enrique McGraw, can you recall this for Monday? Is that enough time, Mr. Roundtree?
I think so, Judge.
All right, and Ms. Ferguson, that'll be for disposition on April 11th.
Thank you, Judge.
You're welcome. And Norman, Mr. Enrique McGraw is excused.
Your Honor, may I speak to my attorney, please?
Who is asking to speak to their attorney?
Sorry, Enrique McGraw.
Judge, I can speak with them maybe when we're finished. I have one other case before you, so I'd like to resolve that first, if I could.
All right, thank you.
Thank you.
All right, and who are the parties on Julia Cassandra Garcia?
That's me, Judge. Tim Roundtree for Ms. Garcia.
Who's the prosecutor?
I believe that
Judge, this
was
is Brittany. I can step in.
All right, thank you. All right, the court is calling 2022 CR 03, State of Texas versus Cassandra Garcia. Could I have parties announced for the record for the state,
Brittany Sparks for state.
for the defense?
Jim Roundtree for Ms. Garcia.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No objections.
Any objections from the defense?
No, Your Honor.
Ms. Garcia, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, Ms. Garcia, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Garcia, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge, we are.
Ms. Garcia, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years of prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 8 years of prison. There's a $1,500 fine prorated. State recommends community supervision. There's no application for deferred adjudication. There's $60 restitution to DPS for laboratory testing, VIP live, DWI intervention, 2-year Texas driver's license suspension, admission interlock half the term, and 10 days in the Bexar County Jail. Did you understand that to be the plea bargain agreement, Ms. Garcia?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence to support the defendant's plea?
Yes, Judge. State offers State Exhibit 1 and all attachments.
No objection.
Ms. Garcia, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, just that Ms. Garcia is a single mom of 2 children, a 12-year-old and a 16-year-old. We would ask that you would follow the plea bargain. In addition, in speaking with Mr. Groomer, he was not opposed to us requesting that you hold the 10 days in abeyance. Her younger child has recently had a significant mental health diagnosis, and I don't want to really go into that on YouTube, but we would be happy to go into that in front of the court only if you needed to hear that, Judge. But she's the only care for them, and we would ask that you would allow her to either serve that at home with the ability to take them to school, or that you would hold it in abeyance.
All right, Ms. Garcia, where were your children during this incident? Who was looking after them?
They were with my mom
And where are your children now?
at school.
When's the last time you had alcohol?
That day.
All right, this is what the court is going to do. Court will sentence you to 8 years in the prison, suspended and probated for 5 years, $1,500 fine probated, VIP live, DWI intervention, 2 years Texas driver's license suspension, ignition interlock for half the term, 200 hours of community service restitution. 40 of those hours will be waived if you provide proof that you've had the COVID vaccination. The court is not requiring anyone to get the COVID vaccination, but if you do, 40 of those hours will be waived. Parenting classes. Ms. Garcia, is Child Protective Services involved?
No, ma'am.
All right, I'm ordering parenting classes. You must complete those parenting classes, and if you complete those parenting classes, the remainder of the community service hours will be waived. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. If something happens and you can't report by Zoom, you need to do it in person. Field visits 2 times per month, random. Regular UAs. And due to COVID, the court will hold the 10 days in the Bexar County Jail in abeyance. Rebecca, is there anything else? I'm sorry, restitution of $60 to DPS. Rebecca, is there anything else she needs?
No, ma'am. You did say the regular reporting, correct?
Yes.
Yes, that's everything.
All right, Ms. Garcia, is there anything else that you need from the court in order to be successful?
No, ma'am.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, with that, we'll go off the record. Ms. Garcia, you're gonna have to do better. You understand?
Yes, Your Honor.
All right. Ms. Garcia, you're gonna be sent to breakout room number 5, and probation will meet you there. Do not leave until probation speaks with you. You understand?
Yes, ma'am.
All right, and then Mr. Roundtree, if you want to speak to Mr. McGraw, I'll send him number 3. You need to make sure he comes back to the main room.
Thank you, Judge.
All right, who are the parties on Damian Simon Leal?
Brittany, Judge.
I'm sorry, who's the defense attorney?
Adam Wilhood, Your Honor.
Thank you.
Judge, do you need me to stay in here or do you?
Yes.
Okay.
Because this is another probation. All right, the court is calling 2022 CR 17998, State of Texas versus Damian Simon Leal. Can I have parties announced for the record for the state?
Brittany Sparks.
For the defense?
Adam Wilhood.
And are you Damian Simon Leal?
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Mr. Leal, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Leal, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, there's 2 cases that he's pleading to. Which one are you on right now?
Oh, just 1 second. I have the second one. And the court is also calling 2022 CR 1801. And that cause number, again, we're proceeding by video. Any objection from the state or the defense?
No objection.
No, Your Honor. No objection.
Mr. Leal, do you have any objections to us proceeding by video? Did you sign the document entitled Consent to Appear by Video Conference?
Yes, Your Honor.
And did you sign the document in that cause number entitled Application for Community Supervision?
Yes, Your Honor.
And counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
In cause number 2022 CR 1801, the state will find that the defendant has knowingly and voluntarily consented to appear by video, and the court will find that the state is in compliance with discovery. Mr. Leal, in that cause number, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State cause number 2022 CR 1801 is the evading. Are you proceeding on that indictment as presented?
Judge, we're going to waive the enhancement in that cause number.
All right, just 1 moment, off the record for a moment. Excuse me, Deputy Lord. All right, we're back on the record. Stated appears in 2022 CR 1801. You're proceeding on the indictment as presented. Is that correct?
Yes, Judge, I apologize. The other one hasn't changed.
No problem. It's a Monday. All right, and then in cause number 2022 CR 1799A, the state is only proceeding on count 1 and waiving count 2. Any objection to the waiver of count 2?
No objections, Your Honor.
All right, Mr. Leal, in cause number 2022 CR 1799A, you're charged with the offense of possession with intent to deliver controlled substance, penalty for 4 grams to 200 grams. That's a first degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
In cause number 2022 CR 1801, you're charged with the offense of evading arrest, detention, second offense. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Do you understand?
Yes, Your Honor.
And each of the cause numbers, if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
And each of the cause numbers, do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent. Did you understand?
Yes, Your Honor.
And each of the cause numbers, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine or confront any witnesses that it's money the state would call the right to remain silent?
Yes, Your Honor.
Did you understand by entering a plea bargain agreement in each of these cases, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreement in each of these cases?
Yes, Your Honor.
Counsel, in each of the cases, has your client been able to provide you with any defenses?
Yes, Your Honor.
In each of these cases, do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
In each of the cases, do you believe he is currently competent, was legally sane at the time of the offense?
Yes, Your Honor. I think he was competent and sane.
All right, Mr. Leal, in each of the cases, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
In each of the cases, has anyone offered you anything other than the plea bargain agreement to get you to enter the plea?
No, Your Honor.
In each of the cause numbers, are you satisfied with the way you've been represented?
Very satisfied.
In each of the cause numbers, are you a U.S. citizen?
Yes, Your Honor.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In cause number 2022 CR 1801, according to your plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's a $1,500 fine probated. There's no application for deferred adjudication. The state recommends community supervision. This will run concurrent with 2022 CR 1799A. State will take in consideration 2022 CR 2288, 2022 CR 1800A. And cause number 2022 CR 1799A, according to the plea bargain agreement, states proceeding on count 1. Punishment is to be assessed at 6 years in the prison. There's a $1,500 fine to be probated. No application for deferred adjudication. State recommends community supervision. This will run concurrent with 2022 CR 1801. State will take in consideration 2022 CR 1800A, 2022 CR 2288. There's $285 restitution to Bexar County for laboratory testing. Did you understand that to be the plea bargain agreement in each of these cause numbers?
Yes, Your Honor.
Defense, is that the plea bargain agreement in each of the cause numbers?
Yes, Your Honor.
State, is that the plea bargain agreement in each of the cause numbers?
Yes, it is, Judge.
In each of the cause numbers, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
And each of the clause numbers, I'm showing you what's outside the agreement. And clause number 2022 CR 17998, the state is requesting that your community supervision be for a term of 6 years. There'll be a TAP evaluation, 200 hours of community service restitution, no contact with Caitlin, K-A-T-E-L-Y-N, Justine, J-U-S-T-I-N-E, Martinez, and a TAP evaluation plus follow all recommendations of the TAP evaluation. And clause number 2022 CR 1801, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 200 hours of community service restitution, no contact with Caitlin, Justin, Martinez, and follow any recommendations from TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
I understand, Your Honor.
Then in each of the cause numbers, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's no contest plea.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments in both cases.
No objections from the defense, Your Honor.
Mr. Leal, in each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you electronically sign them in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right, for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today in each of the cause numbers, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
I understand, Your Honor.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, in each of the cause numbers, the court will find there's sufficient evidence to find you guilty. The court will find you guilty in each of the cause numbers. Are you proceeding with sentencing?
Yes, Judge. No objections from the defense.
All right, anything you wish to say on behalf of your client?
Your Honor, we would just ask the court to please follow the plea bargain as is laid out there. Obviously, we know the court has discretion on all the below the line materials, but we are hoping and asking the court to place Mr. Leal on probation for a term of 6 years on the first degree felony and run concurrent 2 years on the state jail offense.
All right, Mr. Leal, do you have any children?
Yes, ma'am.
What are their ages?
3 and 1.
Where are they?
Right now, they're with their mother.
And that is not this Caitlin person, is it?
No, ma'am.
Do you have any children or any current relationship with the Caitlin person who's in these documents?
No, ma'am.
Are you paying child support?
No, ma'am.
You understand that you have to pay child support if you're on probation.
Yes, ma'am.
Is Child Protective Services involved?
No, ma'am.
So what drugs are you using?
I was using methamphetamines and marijuana.
How often?
Just about every other day, pretty often.
When's the last time you had contact with your parents?
I spoke to my mom yesterday and then my father maybe like 3 days ago.
How far did you go in school?
I have a high school diploma.
What are you planning on doing with the rest of your life?
I really want to minister to people that were in positions like me to keep people from getting involved into a position like this.
All right, that's a nice goal and I like it. But what are you going to be doing to financially support yourself?
I'm going to be working with my mom. She owns a catering company.
All right, you know, sometimes you have to find your own way. You understand?
Yes, ma'am. But that's just to get me back on my feet.
All right. Court is going to sentence you to 6 years and cause number 2022 CR 17998. Court is going to sentence you to 6 years in prison, suspended and probated for 6 years, $1,500 fine, probated, concurrent with 2022 CR 1801. Take in consideration 2022 CR 1800A, 2022 CR 2288. $285 restitution to Bear County Laboratory for testing. There's to be no contact with Caitlin Justine Martinez. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do the COVID vaccination, but if you do, 40 of those hours will be waived. The court is going to require parenting classes with compadre and compadre. And if you complete those, which you must complete those, the remaining community service hours will be waived. I want a referral to felony drug court while in custody. If he's not accepted into felony drug court, then I want him evaluated for ISF. There's to be regular reporting or by Zoom. If for some reason you can't report by Zoom, you need to report in person. Field visits 2 times per month, random. And UA hotline. Rebecca, is there anything else that he needs under that cause number?
The proof of employment, Judge.
Thank you. Proof of employment within 30 days of release. There's
I'm sorry, and to clarify, was that state ISF or the local ISF?
Whichever is the one for drug treatment, and that's only if he's not accepted in felony drug court.
Correct, thank you very much.
You're welcome. There's to be no employment as a home healthcare provider or with minors. And there's to be no unsupervised contact with minors until further notice. So you're not allowed to babysit the children until further notice. You understand, Mr. Leon?
Yes, Your Honor.
We got to get you on the right track so you can be a good parent to them.
Thank you, Your Honor.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal and cause number 2022 CR 17998. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we're going to move on to cause number 2022 CR 1801. As previously stated, the court is finding you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 2 years, $1,500 fine, probated. This is run concurrent with 2022 CR 17998. State will take in consideration 2022 CR 2288. 2022 CR 1800A. No contact with Caitlin Justine Martinez. 200 hours of community service restitution. Again, 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not forcing you to get the COVID vaccination, but if you do, the court will deduct 40 of those hours. Parenting classes with compadre and compadre. You must complete the parenting classes. If you do, the court will waive the remaining of the community service hours. Proof of employment within 30 days of release, no employment as a home healthcare provider with minors, field visits, random, 2 times per month, no unsupervised contact with minors until further notice, referral to felony drug court while in custody. If not accepted, then ISF, UA hotline, regular reporting by Zoom or in person. So if you can't report by Zoom, then you need to report in person. Do you understand, Mr. Leal?
Yes, Your Honor.
All right. Rebecca, is there anything else that he needs?
No, ma'am, that was everything.
Mr. Leal, is there anything else that you need from the court in that cause number to help you be successful?
No, Your Honor. Appreciate you.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because, sorry, just 1 second. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question on what a weapon or ammunition is, then you need to contact an attorney. Do you understand?
Yes, Your Honor.
All right, that will close the record. Mr. Leal, good luck to you. You're gonna have to
Thank
do
you.
better for your children, okay?
Yes, ma'am. Thank you so much.
All right, you're welcome. I'm gonna send you to a breakout room. I'm sending you breakout room number 5. Rebecca, you can go to number 5 now. And Mr. LaHood, you can go to 5, and Ms. Ferguson said that. All right, just a second. All right. You can go to that breakout room, Mr. LaHood. And who is on Christopher Robles?
I'm here, Your Honor.
You're ready for the state.
And it's Joe Ray?
Yes, Judge.
Oh, just have a seat at the table.
You want him at the table, Judge?
Yes, he can sit at the table. All right, court is calling 2020 CR 12348, State of Texas versus Christopher Robles. Can I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense? All right, I think the court reporter is gonna have trouble hearing you.
I'll take the mask off. I'm vaccinated.
All right, we're proceeding by video. Any objections to us proceeding by video, state,
No, Your Honor.
defense?
No, Your Honor.
Mr. Robles, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Robles, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Robles, I'm showing you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
All right, did you understand what you're charged with is evading arrest, detention with the vehicle? That's a third-degree felony. The range of punishment is anywhere. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into the plea bargain agreement in this case?
Sorry, exactly broke up.
Did you intend to enter into a plea bargain agreement and give up those rights? Did you intend to give up those rights, Mr. Robles?
Yes, Your Honor.
And enter into a plea bargain agreement in this case?
Yes, sir.
Did you understand that the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Robles, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor, I did.
According to the plea bargain agreement, there's a $1,500 fine to be probated. State recommends deferred adjudication. They will take in consideration county court cost number 665-826, JN number 1986261. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed and heard and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting 150 hours of community service restitution, defensive driving course, a TAP evaluation, and 5 years deferred adjudication. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence to support the defendant's no contest plea?
State offers State's Exhibit 1, its attachments.
We have no objections, Your Honor.
Mr. Robles, I'm showing you what's entitled waivering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, he's never had any felony convictions, and I think that if given deferred, he successfully completed.
All right, Mr. Robles, why were you going 100 miles per hour?
Trying to, I guess, protect a friend at the time, and it was trying to get him, sticking my nose where it shouldn't have never been, when that's actually the laws. Yeah, that's why the law.
How does doing donuts
I
on a
guess
roadway mean you're saving your friend? I don't understand, because when I run to school, donuts are just, you're turning around in circles at a high rate of speed. So how is that helping your friend?
trying to, I guess, put everything on me when it was a very dumb, a noble but dumb decision that was definitely not worth it.
How old were you?
I was 29 at the time.
All right, are you
or 30.
employed?
Yes, ma'am, I am. Yes, Your Honor.
What do you do?
I'm a heavy machine operator.
All right, do you have any children?
Yes, ma'am, I do.
What are their ages?
I got one boy. He is 9 years old.
Does he live with you?
He's with his mother. He lives with his mother.
Do you pay child support?
Yes, Your Honor, I do.
All right, this is what the court is going to do. I don't know if you can take a defensive driving course without driving, but I don't think you should be driving right now. So it's going to be a $1,500 fine, probated, 5 years deferred adjudication. Take in consideration county court cause number 665-826 and JN number 1986261. 150 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you the COVID vaccination, but if you do, 40 of those hours will be waived. The defense and driving course, proof of employment. There's to be no employment as a home health care provider or with minors, regular reporting in person or in Zoom, field visits, 2 times per month. There's to be no driving until further notice, parenting classes with compadre e compadre.
May I ask a question, Your Honor?
There's to be, just 1 second, regular UAs. Yes, you may ask a question.
Just to clarify, my license is going to be revoked at this time during this?
No, you're not allowed to drive. So you can have a license, but you're not driving.
I think he worked out of, a while back, he was working out of San Antonio. I don't know how he's gonna, that's it, that was his employment.
Well, I mean, you know, that's his problem. Because here's the thing, Mr. Robles, I read this, you were going 100 miles per hour doing
Yes, ma'am.
donuts. And it's not like you're an 18-year-old or a 17-year-old, which they shouldn't be doing it anyway. We should be setting examples for them. You're 29.
I completely agree with you, ma'am. It was very stupid of me.
Yeah, and
to
people
make
could have
those
been killed.
decisions.
This officer said that you were heading towards him at a high rate of speed.
No, ma'am.
He had to pull his weapon.
It was a very dumb decision at the time, and I'm taking this as a punishment, but more as in a way of a life decision that I'm taking it into, not of the 5 years, but for the rest of my life, where I'm going to go to work and build up.
Yes, so this is what the court is going to do. You're not going to be allowed to drive. I'm sorry if your occupation is driving, but you're not going to be allowed to drive because not everyone is ready for the responsibility of driving. And part of the responsibility for driving is not driving recklessly, not going 100 miles per hour. I don't know in any state where 100 miles per hour is the speed limit, unless you're on a racetrack.
Yeah, I agree with you, ma'am. The stipulations of I guess the 5 years, if I am pulled over without a license, that's gonna be provoking my probation, correct?
I mean, you can have a license. What I'm telling you is you're not allowed to drive. So your transportation is going to be via, or either your transportation is going to be someone taking you by Uber, or either your mom or your father or some relative is going to be driving you around. You are not allowed behind the wheel of a car until further notice.
Yes, Your Honor.
And sometimes, yes, probation is rehabilitation, but sometimes there's punishment. And your punishment is you're not going to be allowed to drive until further notice because you were going over 100 miles per hour. You were doing donuts. The officer said that you were bearing down on him, going that speed limit, and he had to pull his weapon. And then you turned around and you continued to do donuts. So part of your punishment, along with your rehabilitation process, is you are not going to be allowed to drive. Do you understand?
Yes, Your Honor, I do.
Now, at some point, I may reconsider that if you show me that you have matured enough where you can be trusted behind the wheel of a car. But for now, you can't be trusted behind the wheel of a car.
Yes, Your Honor.
All right, is there anything else that you need from the court in order to be successful?
No, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Robles. Mr. Robles, I'm going to send you to a breakout room. Probation will go over conditions with you. Please be patient.
Thank you, Your Honor.
You're welcome.
May we be excused?
Yes.
And Mr. Robles, call me after that.
All right, Mr. LaHood.
Thank you, Judge.
You're welcome. Thank you.
Thank you, Mr. Garcia.
Mr. Williams.
Thank you. Judge.
Thank you. Mr. Williams, we're going to have to appoint you another attorney. Regrettably, your attorney has passed. So we're going to appoint you a new attorney. Do you understand?
Yes, Your Honor. Can you hear me?
Yes, we can hear you.
Yes, ma'am. I hear you. I'm sorry to hear that. I was wondering what the situation was, and may he rest in peace, and may God be with him.
All right. So what we're going to do, Mr. Williams, we're going to recall you, and we'll recall you for Monday. Ms. Ferguson, can we recall Mr. Williams for Monday?
Yes, ma'am.
Your Honor, may I ask a question?
Yes.
Is there any way I could get, speak to a lawyer, or who would be my?
That's what I'm saying. We're gonna have to get you an attorney.
Oh, okay.
So just give me a moment, okay?
Yes, ma'am.
See you back on Monday.
Yes, ma'am. I'm sorry for that, and thank you.
All right, you're welcome. Norma, 14M can go back.
All right, thank you, ma'am.
You're welcome. All right, Miguel Hernandez.
Good afternoon, Judge.
Good evening.
Yes, I'm Mr. Eduardo Munoz.
Yes.
Norma called me and said, asked if I could come in. We're set for tomorrow morning, I believe.
Yes, so he'll be brought over dressed for trial unless there's an agreement.
Well, no, we don't have an agreement. I had gotten called by Marcus on this matter, and I think he told me he had a witness that was not going to be there. So I don't know. I mean, I saw him earlier doing a hearing.
Now, this is your trial setting, so he'll be brought back tomorrow for trial.
Okay, Judge. All right, then it's in person at the courthouse?
Yes, he'll be brought over in whatever clothes he has at the jail.
Okay, Judge, we'll be there at 9 o'clock in person.
All right, thank you.
Thank
Norma,
you.
Mr. Munoz can go back. Mr. Munoz, we'll see you tomorrow for jury trial.
Thank you, Judge.
You're welcome. Adam LaHood?
Yes, Your Honor. Norma asked me to stick around for something.
All right, just give me a moment. Ms. Benavides? We're not going to have any other cases that will need the court reporter, but thank you so much for coming.
You're welcome. You're welcome, Judge.
All right.